So if you look over in the table there by the door, we have printed materials. We're not gonna read through the entire presentation, just for the sake of time. We're gonna highlight some of the more important changes that we have made and that we think are most relevant. And we're going to limit questions to 2 minutes, just to try to keep things moving along tonight, okay? Right.
I'm not in the mood that I thought I would be in. I'm a little discombobulated.
Okay.
All right, we should get through it though.
All right.
All right.
Yeah.
Cool. So, dive in. All right, oh gosh.
So, is there anybody here that was at a previous information session, or is everybody, this is relatively new for you? So, this has been a 3-year process for us trying to figure out, a bylaw that's gonna work well for West Newbury, based on what we've observed as a commission over the years and what we've observed in other towns around us, to try to make sure that the bylaw addresses the issues that we have in West Newbury. In the introduction here, what is a wetland and how do I know if I have a wetland? So when you want to do a project near a wetland, within 100 feet of a wetland, it is already now something that you need to permit. And we determine a wetland is a wetland based on whether we can tell if the land has been inundated with water, and that's usually through soils. Soils is kind of the baseline. We look at vegetation, and we look at the way the water moves across the land as well. And a wetlands delineation is the only way to accurately make sure that we know where the border between dry land and wetland is. So since 1972, the Wetlands Protection Act has been in place.
I'm trying to multitask. and
yeah.
it's going on well.
So under the Wetlands Protection Act from 1972, as it is now, any person who wants to remove, fill, dredge, or alter an area that is considered a wetland, they first have to file with the Conservation Commission. That's already in place. That's been in place since 1972. So most towns in the Commonwealth have bylaws. And why do they have bylaws? Because we've just determined that the Wetlands Protection Act, while a good start, doesn't necessarily protect all of the wetlands in a community. West Newbury has kind of famously clay soils that don't allow water to infiltrate very well. So we have a lot of wetland problems to deal with. Having the bylaw will increase community control over our unique circumstances here in town. It will reduce community costs, hopefully, by reducing the amount of time and energy we have to spend mitigating degradation of wetlands. We're hoping it'll make the community more sustainable during climate change. And enhanced protections of the community's wetlands will retain the values that wetlands provides: flood storage and filtering our drinking water.
That's it.
So, the town also has longstanding objectives that have included having a wetlands protection bylaw. So, as you can see, all of these different plans that have been made by the towns over the last 5 years, 6 years, have included a wetlands protection bylaw. So, these are some of the things that you can and can't do right now. And, well, no, these are the things that we can and can't do with a bylaw. So, the home rule authority is what allows us to say, okay, we have our town, we have the people that live in our town, we get to make the rules. that as we see fit for our town. This is what allows us to have zoning, and this is what allows us to enhance the protection of our wetlands. We have to make, if we're gonna do a bylaw, it has to be more protective of the wetlands than the Wetlands Protection Act already. We can't take away regulations from the Wetlands Protection Act as it stands for the state. So any bylaw that, any of the towns that you see around us that have bylaws, have enacted bylaws in order to protect more wetlands or more values for wetlands. Let's see. More stringent, I think it's a lot of words, but you guys you can read that on your own as well. And if you have questions, you can let us know. So as I said, you know, the majority of towns in Massachusetts have adopted bylaws. And if you look back at that map, you can kind of see which towns have adopted bylaws, and if you make a guess as to why, these are towns that have a lot of wetlands perhaps, but they're also towns that are closer to urban areas and are probably facing some pressure of having more development. These are towns that have decided that maybe they need to protect wetlands from additional pressures. So in Essex County, 85% of municipalities have adopted wetlands protection bylaw. So this is a list of what we have determined we feel are most important things for West Newbury to protect. So first is the 100-foot buffer zone. Already you need to have, yes.
May I ask a question? Within our community, we've had several orders of restriction that have been, that we filed with the Essex County, and we were told that that's a 200. Can you explain that?
It's a 200-foot riverfront resource area around rivers and perennial streams. It's 100 feet off the edge of wetlands, and intermittent streams. That's what's protected today under the Wetlands Protection Act.
Okay, so basically so it's already 200 feet for anyone who lives on
Merrimack
around
River.
the Merrimack
Yeah.
River. This is an additional 100 feet.
No, this is within that 200.
That first 100 feet out from the edge of the bank of the river becomes a new resource area under this bylaw. Today, it's a regulated area under the act.
So is it 200 with restrictions or 300 in total?
200 in total.
Allowed to just,
So how
Can
do we
we-
get 200 plus? I don't understand how the 200 and the 100.
Molly, do you wanna get through the slideshow and then we can do questions after? And then
Yeah.
anyone that's on Zoom, if you wanna mute yourself, and we'll take questions through Zoom after we get through the presentation.
I just wish you wouldn't let people in the audience interrupt the presentation.
I understand, we're getting back on track now.
Okay. So we'll address that after.
No worries.
Okay, so vernal pools are currently only protected if they're part of another wetland system. So this allows vernal pools to also be protected on their own merits. This is number 3, entire areas extending out 100 feet from the edge of vernal pools. So not only the vernal pool itself, but the buffer zone around it. This our bylaw offers protections for smaller ponds. We have, initially we said 1,000 square feet. We've decided to raise that to 5,000 square feet. In the state Wetlands Protection Act, it's 10,000 square feet. Protections for smaller isolated wetlands. So these are areas that maybe are flood storage in the springtime. Expanded protection of additional resource area values. Those are listed below. So this is a way to say that we are also understanding that these values are part of wetlands protection. And ability for the commission to issue fines. This is a way to deter people from violating the Wetlands Protection Act and hopefully come to a quicker resolution. So what will not be changed from the act and the proposed wetlands protection bylaw is all activities that are exempt from filing under the act today will remain exempt. So these are things like vista pruning
Putting in
and,
a deck if you're over 50 feet away from a wetland.
yeah.
They're
Putting,
minor, small projects that they're exempt today under the State Wetlands Protection Act. Planting native plants is an exempt activity,
putting a path in,
putting in a fence,
yeah.
an example.
So, and those are listed in the current regulations. So, no new forms. You're not gonna have to spend more time filling out more paperwork. It's gonna be the same forms that people have been filling out the whole time. No new permits. The permits are going to remain, the permit will be issued under both the bylaw and the act. No changes to abutter notifications for notice of intent filings. This is something that we've reduced also from our original proposed bylaw. Notice is still only required for abutters within 100 feet of the property line where work is proposed. No new abutter notifications required for requests for determination of applicability. No notifications are required for that. And a 200-foot buffer around the intermittent streams is no longer proposed. So there is still, as we said, a 200-foot buffer around perennial streams and rivers, but not around intermittent streams. So, this is how we understand the values that are protected under, well, these are the resource areas protected under the Wetlands Protection Act on the left-hand column. On the right-hand column are resource areas proposed to be protected by the new Wetlands Protection Bylaw. So, as this is just another way of explaining what we just explained in the previous slide. So the public interest currently protected under the Wetlands Protection Act. This is, if you look at the difference between what is currently protected and what we're proposing, we're also proposing to protect agriculture, recreation, rare species habitat, water quality, and aquaculture, and preventing storm damage from coastal storm flowage, which we've all experienced in the last year, and control of erosion and sedimentation. So this slide is talking about why it's so important to have a wetlands bylaw that protects buffer zones as a resource area. So why the 100 feet from the edge of the wetland? Why do we need to protect that? But the vegetation around the wetland allows water flow to slow down and allows the water to infiltrate. It allows better flood control, which we're seeing, with greater, more frequent rainstorms. We need more flood control. Let's see, stronger protections of the buffer zone ultimately ensures wetlands can properly function and provide integral community benefits. So wetlands are like a big sponge. They allow polluted water coming off of streets, coming off of agricultural fields to slowly infiltrate and get clean before it gets into the water table. And what we're also hoping is that by having a bylaw, it's more clear the process to get a permit and that everybody has the same chance of getting equal treatment. And it just makes it easier for us to consistently apply the Wetlands Protection Act. So this is a great illustration of how not just the stream, but all the land around the stream is important for all these different values that are listed here. All the way out to 300 feet, all that land is used by wildlife. up to 200 feet, that's valuable to keep that vegetated for flood control and sediment control. So you can, this I think illustrates why we want to protect that 100-foot buffer and be able to have performance standards in that 100 feet beyond the edge of the wetland. So now we're gonna get into kind of the nitty-gritty of these new resource areas that we are trying to, well, they're not new resource areas, they're resource areas that we would want the bylaw to protect. So smaller ponds and isolated wetlands. These are ponds that maybe are not connected to other bodies of water, not connected to other wetlands. They might be a great habitat for a variety of species. If you look out and see flooded fields, you see ducks swimming in the fields. They're also providing groundwater recharge and flood control instead of that water just running off and collecting sediment. It is ponding and infiltrating. They provide 2 times better retention of nutrients and pollutants. Those are things we don't want getting into the river and to our water supply. And they store water during precipitation events. And all this hopefully protects the water supply for everyone, not only public water supply, but private water supply. I think that was a question. You know, something that you do on your land could affect the water supply of your neighbors. So this is another great illustration of how water moves across the landscape and why it's important to protect areas where water might be ponding or and what happens to water after it's running down a hillside. So, you know, I mean, as we've said, wetlands really do absorb a lot of, well, we say nutrient, I think we think of nutrients as a positive thing, but when we're looking at water, nutrients are not a positive thing. They, you know, contribute to algae blooms, they contribute to other
Impaired water quality.
impaired water quality. It's just, so having healthy wetlands allows for those things to get filtered out of the water. Okay, so now we're moving on to vernal pools. So what made me really want to have this part of the bylaw is that vernal pools as they are now can often be overlooked. And if they're not connected to another wetland, if they're just a low spot in the woods, they could very easily be destroyed. And the thing about vernal pools is you can't mitigate a lost vernal pool. Once you lose a vernal pool, that habitat for the animals that live there cannot be recreated. So having a stronger protection of vernal pools, and I have to say, they're really, how many do we have certified in West Newbury?
Under a dozen.
So we have under a dozen certified vernal pools in West Newbury. It's not,
Say half of those too, just thinking about it, half of those are on land that's already protected. So there's actually one behind the Action Cove Playground, so it's not really impacting anyone. River Road Reservation, the new Greenbelt property has one. The Green Wildlife Management area has a ton of them, some in West Newbury, a lot more in Georgetown. So a lot of them aren't even on privately owned lands, they're protected public land.
but I think they're a particularly vulnerable part of the landscape. And as I said, like they can't be, you can't make another vernal pool once you destroy one. So keeping
Is there
them.
a map of them?
Yep, that's online. I can send that out to anyone who asks for it after.
Thank you.
Yeah.
Okay.
Next one.
So this slide gives you a little bit more information about the life cycle of a spotted salamander. These are animals that lay their eggs in vernal pools. Vernal pools are shallow woodland ponds that are really only wet for part of the year. So they dry completely at the end of the summer. But these salamanders are obligated to lay their eggs in these ponds, in these pools. They spend like the first half of their year hatching, laying the eggs hatch, and then by the end of the, once the pool dries out, they just go into the uplands around the pool. And these salamanders can travel up to
1,800 feet.
1,800 feet, and we're just asking for 100 feet to be protected around these pools. So it's an example of an animal that is required to have this pool, is required to have a lot of habitat around the pool. So we're just trying to make it so they have at least a portion of that. And that's just one example of a species that uses vernal pools and is obligated to use vernal pools. There are many other species like wood frogs and fairy shrimp that are not found in any other habitats. Okay, so I think this is an interesting slide for folks who maybe think that the State Wetlands Protection Act is adequate and that we don't need additional regulations. So this is just a look at some surrounding towns, all of which have approved their bylaws, and it's a comparison of our bylaw compared to theirs. So all of them protect the 100-foot buffer zone as a resource area. That is across the board recognized as something that is important to do in order to better protect that 100-foot buffer zone. You're having to get a permit to work in it anyway. This is a way to make sure that everybody is expected to treat that 100-foot buffer zone the same way. Vernal pools are all protected by these towns as well. Small ponds smaller than the 10,000 square foot pond that is required in the act. So we've limited our protections to ponds that are 5,000 square feet or bigger. If you look down this list, you have Amesbury and Haverhill protecting ponds of any size. So that could be, a tiny puddle. So I think that was a concern definitely earlier on in our, in some of our information sessions. We wanted to avoid that because I just felt like it was going to cause a problem. If someone just dug a hole in their backyard and called it a pond, then this could have now a buffer zone around it. So isolated wetlands, smaller than, again, the act doesn't, it's a complicated calculation to understand what an isolated wetland is in the act. It has to do with how many feet of water it holds. We decided to clarify that, simplify it a little by just saying 5. Again, you see some other towns was going to be a popular choice for West Newbury. We want to make sure that we saw and we looked at, what could be the smallest pond we could imagine that would need protection. Commission can issue fines for work or alteration in a jurisdictional area without a permit. So as you can see, the fee schedule for different or the fine schedule for different towns is pretty variable. We proposed $300 per violation per day as a way to simplify fines. And as a side note, I would say, there really aren't a lot of violations or enforcements that we've been working on where we would even issue a fine. It's for people who are not trying to mitigate the situation in any way. We have many people who have had violations and once notified, they try to rectify the situation. Those are not people that would get a fine. The people that would get a fine are people who are continuing to cause a problem for wetlands over the course of many months. Yep,
The last real slide.
all right. So,
Give me 1 second, I'm gonna stop sharing, I'm gonna go ahead and try to drop the Google Drive link into the chat, so everyone on the chat has access to these PDF documents. And I don't know, Molly, if it makes sense, if you wanna try to take comments from the audience in person first, and then we can switch to comments from Zoom, just to have it
sure.
be, and then anyone that's joining on Zoom, if you have a question, if you wanna raise your hand, I think Zoom will put you in a nice order if you raise their hand first, and as we get to it, I will let you know that your time is ready. And then Molly, are you doing 2 minutes
2 minutes.
for comments?
Yeah.
And do we need people to state their name and address for the record?
Yeah.
Okay,
That'd be helpful.
okay. Give me 1 second, I'll let you know when I'm queued up in here.
Okay.
I think everyone has their name. And then there's that one person in the waiting room and once again, seeing that I've stopped sharing my screen and the TV has frozen on my screen, so. It'll be fine for this room. Okay,
Okay,
okay.
all right, so now we can open the floor to questions, if anybody heard anything that was concerning to them or would like clarification, we can try to talk you through it, and, you know, we're open to feedback, we'd like to hear what people think. You know, this is something we've worked on really hard on and, you know, really tried to make it in line with all the communities in our county and as well as West Newbury's kind of particular situation and population. Hi, Wendy.
Wendy Reed, 71 Bridge Street. On the fine, section, how do those fines compare with other town departments, that also have the ability to issue fines?
Yeah,
I've done the research.
yeah, Michelle has quite a bit of information.
They're on par. The fines in town range anywhere from $25 for, you know, I think the dog bylaw has a lot of $25 fines in it, to other fines that are $300. And then certain fines or enforcement mechanisms like building permits can be doubled. So that actually works out to be thousands of dollars. I think we've had a couple in violation lately that worked out to be, you know, doubled at $4,000 to $6,000. Being able to fine per violation per day is on par with just about all of the other town bylaws, everything from scenic roads bylaws to, using your well water to irrigate during a drought. It's all per violation per day, so that is on par with the other fines in town.
Thanks.
Yeah.
To clarify, it wouldn't be your well water, it would be the town water.
It's the town, yeah, did I say, well, I'm sorry, the public water supply, I apologize. Those aren't our bylaws, so. Irrigation on your public water.
Right.
Sorry about that, you guys keeping me
Use your well water, how you.
straight and honest.
Yeah. Yes.
Robin Krasinski, 7 Summer Street Lane, West Newbury. Section 3.4, routine mowing and maintenance of lawns, gardens, and landscape areas. It says the commission has added for clarity, explicit exemptions allowing for the normal mowing and maintenance of all lawn, garden, and landscape areas that were lawfully in existence prior to the effective date of the bylaw. No lawfully existing lawns, garden, or landscape area will have to change because of this bylaw. Could you clarify that, for instance, how do you define it was lawfully in existence prior to this bylaw?
So, sometimes when there's a question as to someone mowing close to, a resource area, often we've looked back at satellite photos to make sure that it's been mowed consistently since before the Wetlands Protection Act.
Of 1972.
Right. So and often we can see that on satellite imagery, if something's been mowed consistently, then that was not illegal at the time, and so it's, if you've continuously mowed it since then it's not a problem.
And I would say the other example is if you had a house, it's a lot of land, the developer or yourself bought a lot of land, you pulled the permits to create a house and a lawn and a landscaped area in a buffer zone, that's also lawful creation of a lawn that was lawfully in existence before the effect of the bylaw. So the commission's not gonna go back retroactively and tell you you can't mow that lawn. It was lawfully created at the time.
So I want to understand that. You're looking for 52 years of consistent mowing. Is that correct?
If it's a level.
I mean, if it's a wetland and you can usually see that, but what Michelle's saying also is if your house has been built and you've had it permitted since
1980.
in 1980.
1980.
Okay,
1980 forward, if you had permits pulled for your house, which you probably did, even if you didn't build it yourself, because the Wetlands Protection Act and regulations were in existence then that area that was shown on the plans that were approved during permitting, that is the lawn around your house, can continue to be mowed with no impacts from this bylaw.
What about similar situation, say you had a deck that needed replacement or repair or a bulkhead and it's within that area? What was already in there, how does that impact?
for repair and replacement, it's,
If you're not doing any ground alteration, it wouldn't trigger a permit under the Wetlands Protection Act today or under the bylaw. There's also exemptions under the Wetlands Protection Act today that are recognized in this bylaw. So if you were doing maintenance and you had to put in, say, new sonotubes, or say you wanted to put in a whole new deck off your house, if that's over 50 feet away from the edge of a wetland or the edge of the river, you don't need a permit today. If you were putting in a whole new deck closer than 50 feet to a wetland or river, you would need a permit today under the Wetlands Protection Act, and you would still need a permit under the bylaw if it was adopted. It would be one permit under both the act and the bylaw.
What if it was within that 50-foot buffer because it is prior to 1980?
So it's an existing permitting within the existing permitted deck within that 50-foot buffer. If you're not doing any ground disturbance, you're just replacing decking, railings, there's no permits. If you had to start excavating for sonotubes, you would be required to get a permit, and you are required to get a permit for that today under the Wetlands Protection Act. There's no change there.
But what else would be required? Would there be a wetland? All these other things that you're imposing that you can request to have filed, if
So-
it's engineers. and-
It's one permit filing, and so whether you need an engineer or a wetland scientist to delineate the area is gonna be dependent on how close to the edge of the wetland or the edge of the river that deck is. And that's what's required today. So typically what the process is someone gives me a call or someone pulls a building permit for a deck, I get that for review and sign off. I'm the conservation agent for anyone that doesn't know me. I'm the staff person for the Conservation Commission. I'll look at that. I'll look at it against any historical plans that we have for your house or your deck when it was permitted the first time, against aerial mapping. And then I'll reach out to you and I'll let you know what we need to do. I'll let you know, hey, it's exempt, I'm signing off, but just so you know, it's in the 100-foot buffer zone. Future projects could require permitting, or I'll let you know, hey, this is gonna need permitting. Because you're X feet away, you're gonna either need to file for an RDA or a notice of intent, and then I'm gonna walk you through the process. None of that changes with the bylaw. That you would still file for those two same permitting types. That's the slide where Molly read that there's no new types of filings, that it would be filed and permitted under the existing state forms.
so you wouldn't need additional services other than what you're already required to do.
So
If you-
6.8, the consultants, that would happen if you've got something existing, filing permits, and talking about having extra things looked at.
6.8 on consultants is when the commission needs technical review of a new project, and that is, I think at the end, it's caveated that it's gonna be on typically larger complex projects, am I on the right section on that? I'm going from memory here, so you can tell me if I'm off.
Yeah.
So that is, say someone is coming in and they wanna put in, 3 houses, and to do that, they have to build a common driveway, and that common driveway has to cross wetlands. That's a larger complex project, so the commission's gonna require that there's a third-party consultant involved to review the delineation of the wetland. That's the process today, that's a policy adopted by the commission under Mass state law. The bylaw is just codifying that existing policy. But for something like a deck, no, you wouldn't need a consultant for that.
Yeah.
The commission's obviously spent a lot of time preparing and vetting through this wetland protection bylaws. I spent 5 hours today going through this line by line by line. And I've been building, developing and selling in this town for 42 years. So I would argue that I probably have more experience than most here doing it. This is very difficult for a layperson, non-engineer, botanist, wetland scientist to read. Have you considered, because this is going to come before the town, of putting together a side-by-side simplified version of what's here and say, this is what current Wetlands Protection Act is,
Yeah.
and this is what we are proposing in very simple terms, so people understand what they're actually voting on.
So
So
you
that
have,
was the attempt to be annotated.
Yeah, I know, but it's.
Yeah. It's still
it's
a
not
lot of,
there.
yeah.
I think, if I could, I think one of the issues is that the Wetlands Protection Act and regulations are complicated. And you have worked with it, you could agree that the layperson isn't going to understand that. What we've had trouble with is trying to figure out where the gaps in knowledge are between and we've had questions come up today that show that the average person may not understand fully the Wetlands Protection Act. How do you create an easy to read document that addresses all of those existing areas and then tries to explain it? I think the slideshow highlights what those changes are in easy form.
But it's very, again, not to be redundant, but it's very difficult for somebody to vote on something like this, because this is a significant change from what is in place today. I've made several notes, but am I gonna be limited to these 2-minute little intervals here?
Well, we'd like to keep.
It's very difficult when you go through a half-hour slideshow to limit somebody to 2 minutes, it really is.
I think what we're trying to do is make sure that everybody has an opportunity for input, so we can cycle
Absolutely. I
back.
I'm not looking to monopolize time, it's just I have several points, I've got about 4 pages of notes and questions.
Okay, well, let's see if anybody else has questions, we'll come back to you,
Yeah.
and then. Two more minutes.
Questions?
Okay,
Yeah, and we're gonna get through the room first.
and, can you just remember to state your name before?
I'm sorry.
Yeah.
Mark Dickinson.
Martha, okay. Yes,
there was a lot of work done on this too, I agree with Mark on that. But my overall question though, what is this proposal? Are there specific problems that you're trying to solve, or is this really a general?
it's not specific problems, I think it's. Well, I was talking to Michelle about this a little bit, I feel like it's maintenance, I feel like it's wetlands maintenance, like we need to maintain the wetlands in good condition. And as we see bigger problems with climate change, more severe storms, there's about an average of 15 houses built in town a year. As we address those changes to the town, I think it's important to also know that with those added pressures, we need to also make sure that the wetlands stay healthy and are performing the way they need to perform.
That's the purpose of the Massachusetts law too. So I'm just trying to understand I know all the other towns are doing it, but
Right. Well, the Massachusetts law was written in 1972, so since then, we've learned a lot more about the value of safe vernal pools. And that we can't replicate them, and so this is a way to say, okay, here's what we've learned, and here's how we can improve the function of the wetlands.
And so for vernal pools, I think you said there's about a dozen, and half of those are already in public land, so there's only 6 vernal pools that are looking, I mean, it's a lot of work. You know what I mean?
Well, and that's, yeah, that's part of what we need to do, and we can't save them without having a bylaw.
Well,
So,
they're already protected.
no, they're not. They're only protected, they're only protected if they're attached to another wetland, and only that wetlands buffer zone applies to them. So a lot of them aren't necessarily next to another wetland, they're isolated in their own. And so this is a way to make sure that they are protected.
And by reducing the size from 10,000, of a pond from 10,000 to 5,000, how many people in town does that affect?
How many people in town live on Vex? I don't know.
What was, oh, the size of ponds?
Yeah.
I think when we did a GIS mapping survey, when we received the feedback that some people thought, you know, reducing that size threshold from 10,000 square feet where it is at the act down to 1,000 square feet was too small. So reviewing mapping, I think we came up with 3 or 4 ponds that were below that 10,000 square foot threshold that would receive protections now because they're between 5 and 10,000 square feet. Right now, under the act, the protections start at ponds that are 10,000 square feet. So it's a smaller number.
We have a bylaw for 3 ponds and 6 pools.
I think a bigger portion of the bylaw is changing that buffer zone into a protected resource area. It's not a protected resource area today under the act. That's the biggest change.
Yeah.
Sorry, Molly, I didn't mean to.
No, I mean, yeah, I mean, I don't think that we can say exactly who's going to be affected by anything, and the nature of wetlands is that the lines change every 3 years, potentially. That's why we have to have, that's why a notice of intent only is good for 3 years, because we need to go back and see where the wetlands actually exist. So it's really hard to map things and know exactly who's affected by what. Perpetually.
Before you go back to Robin, I have people in the Zoom, unless there's anyone else new, sorry. Okay, thank you, I didn't see you.
Right, my name's Anne Sanchez Felix, 335 Main Street. It says here, a 200-foot buffer around an intermittent stream is no longer proposed, the 200-foot riverfront, it goes on. What do you classify as an intermittent stream?
It's going, the bylaw is going to follow the definition of the Wetlands Protection Act. Any wetland resource area, or any term that's not defined differently in the bylaw follows the definition that exists today under the act. So offhand, it's a lengthy one. I'll do my best. So it is a area of flowing water. It has to run down gradient. If it is a seep that flows out of the ground, it doesn't become an intermittent stream until it flows from or through a wetland. Once a channel of water leaves a wetland and is flowing, that is when it becomes a stream. I can send you the exact definition. Intermittent means it doesn't flow year round. So there's an analyst for that. They look at, it's a program, you can run it online. It's perennial if it meets certain criteria for watershed and how much volume of water it flows year round is the lay way to say it, but there's actually data you can look at to determine if it's perennial or intermittent. If it doesn't meet that criteria, it's an intermittent stream.
So I think, I don't know if your question is asking about that slide in particular. The first iteration of the proposed bylaw proposed a 200-foot buffer around those types of streams, and we have since removed that. So now they have this, so now
It's 100 feet off an intermittent stream.
Yeah, okay, so I've also gone through this document slowly and looked at, section 2 really is quite an expanded jurisdiction. It affects lots of people. It talks about expanded areas that will be affected. I have an old antique house. A lot of you been to my property already in Keenan. It was built probably well after the stream was established. It's been there a long time. Probably my whole yard is now a buffer zone.
It is a buffer zone
And I
today.
was not aware of that when I bought the property. So there will be a lot of people in West Newbury that may also feel that now with the climate intensity building, there might be people on the tipping point of what becomes a wetland and they don't even know it yet, and neither do you. So, these woodlands that are sort of getting foggier by the season are, going to form a tipping point, and it will affect many, many more residents in West Newbury. So that's just one of my concerns. Section 6.4, it looks like the Wetlands Commission can basically introduce any consultant at the cost of the landowner, the house owner. Which is rather worrying that it's a blank check. You know, we're doing a lot to protect the wildlife, but what are we doing to protect the neighbors in West Newbury? I mean, you know, I'm not used to talking as my own advocate here. I'm a nurse by trade and I'm used to being an advocate for patients and the vulnerable community. I feel for us as a neighborhood and as a community that there isn't nothing for landowners. And there's a lot to say about, you know, I too like native plants. I do protect, you know, I'm for protecting trees. But where you can't protect your own land and you can't protect your property and your investment, it's a grave concern to our community. That's one. And the last point is where you make your decisions at point 8, decisions and conditions. It really is unclear. It's going to be case by case, but you know, there's also obviously a lot of, you know, undescribed conditions to us as to what your criteria might be to pass or deny an application. And it doesn't seem like it could be uniform and that the set criteria, but it could become potentially personal, or, you know, if you struggled with a particular group of people to get the action you want on the wetlands, that you might take strides to make that difficult for them. So that concerns me somewhat. It seems to me that we're giving you a lot of authority over the landowners, and there isn't much support for people who have property and have money invested in their property. And he's equally not really noticed, you know, considering people's financial conditions, and you know, whether they can even afford to protect the wetlands. So my question is, what is the protection for landowners and homeowners, and our neighbours and our community in West Newbury? Because we are protecting these lovely creatures, the amphibians and so forth. I totally agree. We want to purify our water, but we are at a tipping point where, you know, the intensity of the rainfall we're seeing is increasing worldwide. I've just come back from UK. We've had an immense amount of rainfall there.
I'm just gonna stop you because it's been more than 2 minutes, but,
Thank you for thinking.
yeah,
Molly, I'm gonna pull up one of the slides really quick.
okay.
Thank you for speaking for us. Thank you very much.
That's really good. It's worth not to have misinformation though.
They're right here, and if you took one of the copies of the slideshow, you'll have it as well. So a lot of the comments that you shared are related to the Wetlands Protection Act today. So with or without this bylaw, a lot of what you shared are impacts that homeowners are feeling today. Wetlands are changing. We're having, well, you know it, I don't need to explain it to you, but we're having more frequent, more severe storms, and people are being put into this position where they're not in a position where financially they can fix their infrastructure, their driveways, their property in compliance with what's required under the State Wetlands Protection Act. The commission's bylaw can't change anything there. It can't make the Wetlands Protection Act less stringent than it is today. So with or without the bylaw, the way the act is written will remain. But I do want to call out attention to this last bullet here. It's timely. The clock is ticking. Mass DEP is working on revisions to the state regulations under the act, because they are recognizing that they have a changing climate. There needs to be updates here. So they're accepting public comments through April 30th. They have one set of revisions already out. They're available to review online. They're working on another set of revisions. Allegedly, those will be out in June. So I think if you needed or wanted to get comments out to the state to have them understand and maybe take some proactive measures on this, that might be an opportunity as well. These problems aren't going away with or without this bylaw, unfortunately.
Yeah, they're already proposing adding new exemptions, right, for like trail maintenance, for example.
And invasive plants is something that's being considered for round 2.
Anything
And
that
should
they
people who
add.
buy a property know that you are buying something in a wetland? Should this be some kind of notification that?
I think there should be. I think
Because,
your
you know,
realtor should be
It's very
telling
little
you.
protection for a homeowner. When I bought my home, I had an intermittent stream. I don't know whether it still fits that definition. But, I was not aware that therefore my whole of my property is considered wetlands. And therefore, if I want to put a patio in or request anything, I have to go through this notification. I was not aware of that, and I think that there should be some protection for homeowners because there's a lot going one way and not
Right,
a two-way street here. Thank you.
yeah, and should should the warning, you should know that before you go into a purchase of real estate, probably. Looking at-
I'm curious, how do you think that the realtor should do that? Do you think the realtor should have delineation?
No, I think that if there are conditions on your house,
If there's conditions, it would be stated.
Right, and it's recorded.
and it often is, and people maybe buy homes without realizing there are conditions
But-
on their homes.
An order of conditions, that might have been done when they were
Yeah,
built,
one's
but that's all
There-
that's usually signed off on.
Right,
There are some that run with the deed.
correct, because you have a COC.
There's still,
But I think to answer the question, the fact that there is a recorded order of conditions, even if it was properly closed out with a certificate of compliance, whether or not there's ongoing conditions that follow the property is irrelevant. The fact that there was that wetlands permitting document
No question.
should cue people into that. And unfortunately, I do see it where, people buy properties, there's really good realtors in this town. This town has some excellent realtors and they reach out to me and I'm able to review everything with them. And then other people buy property and they have no idea that it's wetlands. And so it is a hard place.
Just so you know, that comes up in the title search,
right.
and that's the attorney doing it and not the realtor.
Not the
So,
realtor.
okay, so maybe it's the attorney that should
Right. That's
be
the attorney.
drawing their attention to it.
100%.
Yeah.
If there's any encroachment, if there's any orders of conditions, if there's any outstanding orders, and oftentimes we find this out once the title is done, okay? And Michelle, you know this. I mean, I
I
can
worked in it.
walk you around the town and tell you all the roads that open orders of conditions are on. We've all seen it.
Yeah,
I think, I have a background where I used to work at a real estate law office, so I would see it from the closing attorney side of things. And I think, kind of speaking to where the problem is, and this isn't a matter of pointing fingers. But if an order of conditions is recorded, it shows up on the title report, and it shows up that it's closed out successfully, then that doesn't get communicated to the buyer. The buyer, from my experience, is often not told, hey, just so you know, this isn't an issue, but you're buying a property that's in wetlands or buffer zone of wetlands. So yes, they're looking at it and they're making sure it's closed out for their, home buyers protection, but they're not communicating what the implications of that ever showing on title means for the homeowner. So
Right.
maybe a little education all around could help out.
But there again, that's not for the realtor to do, that's for the attorney to do,
Fair enough.
right?
Madam Chair, can you allow some Zoom participants to speak and stay on the subject of the bylaw?
yes, absolutely. Does that cover everybody that's in the room for the moment? Okay,
I'm gonna assume that Zoom pops comes up in chronological order from where they were raised. So I have Ross Capilupo, with his hand up first.
okay.
Hi, everybody. Thanks for the opportunity to speak. I just wanted to make some comments and I will try and keep it within the 2 minutes. I think it's a good goal to preserve the wetlands and all the different species that live in the wetlands, but I think it's an important reminder that people also live in proximity to wetlands. The sketch that you guys showed with the 200-foot buffer zone and then human activity or occupancy after that isn't always the case. A lot of people live within 100 to 200 feet of a wetland area. And, a salamander and a human don't live in the same habitat. There's a conflict there. What's good for a child to go out in the backyard and be around is not the same as what's good for a salamander. And I do feel like sometimes these environmental laws forget the fact that people are at stake too. And I don't think that the well-being of a salamander should be put above the well-being of, say, children with a backyard that don't want to be in an area that's unmowed and infested with ticks or mosquitoes, etc. So that's one thought on the buffer zone. As far as the fines go, I don't necessarily agree that the proposed fines are commensurate with the surrounding towns. It appears to me that it's tied for the highest minimum fine with Haverhill, who has a much larger commercial base. It's a much larger town. And I would argue the character of Haverhill is vastly different from the character in this town. I was told that we don't have very many infractions in this town. We have a very environmentally conscious population. I think the select board is very environmentally conscious. And I don't really understand why in a town that already is environmentally conscious, we need to have such a heavy penalty for disagreeing with this commission. And my last thought is that it's my understanding that when there is a disagreement under the current arrangement, it would be necessary for the town through the commission to pursue litigation through the DEP. And I might be getting some of the particulars mixed up there, but the long and short of it is that it's the onus on the town to take legal steps. And it's also my understanding that under the proposed bylaw, that onus would shift to the homeowner. So you guys would be the judge and jury as far as who gets this fine applied to them. And if somebody disagrees with it and resolution cannot be found, now you have homeowners that have the expectation of litigating the town. And I think that shift in burden and responsibility is very unfair. I mean, $300 a day, that's $2,100 a week. This is a lot of dough for average people. And this could be very minor infractions. I mean, what if somebody's out in a buffer zone clearing dead trees and getting rid of bittersweet, an invasive vine? That's a problem under this bylaw, but it's not a problem for somebody who's trying to live their life and use their property as somebody else had suggested. So anyway, those are my thoughts. Hopefully it didn't sound like a harangue, but I do appreciate you guys taking the time to explain what you're trying to do. And I also appreciate you hearing me out. Thank you.
Yeah, I mean, I see what you're saying, comparing the different fine structure. And we've never, it's hard to tell what the future would be, but Michelle can kind of talk a little bit about like why we think the fines are important. And
I think mostly the fines are a deterrent, think of all of the rules that you don't break as a member of society because there's a financial penalty involved and a lot of things that maybe, I don't know, aren't something that you consider as a big deal. You start a bathroom renovation before you pull your building permit. How's that gonna impact the community? Well, there's penalties there, right? The building inspector finds out, they come to pull permit for something else, eventually you can have fines doubled. So it's on par. Fines are a deterrent to breaking the law, speeding tickets, the irrigation bylaw, it's a deterrent. I can't, like Molly said, see the future, but I know this commission really, really well, and I know my values and I know how much work it is to issue fines and follow up on fines and go to court over fines for judges who will probably laugh and be like, why are you wasting my time here with a fine because someone cut down a couple of trees or cleared some bittersweet in a buffer zone without a permit. Those aren't situations where fines will be issued. Fines will mostly be hey, we noticed you cleared dead trees in the buffer zone without a permit, it's a violation under the act. Come to the Conservation Commission meeting, let's discuss it, that's the process today. The conversation is usually, hey, I'm the homeowner, I had no idea this was a protected resource area, I had no idea I couldn't maintain trees on my property. The commission is, hey, this is the Wetlands Protection Act, 100-foot buffer zone, needed a permit. Don't do any more tree removal unless you get a permit and let the area naturally restore on its own. That is, I would say 90% of what we see. I think we have 3 of those exact types of violations on our upcoming meeting agenda. There wouldn't be fines issued. However, we have had projects in town. There's 2 of them that come to mind and those projects were permitted, but the conditions weren't followed. So when you get a permit, you have conditions that you won't release discharges of sedimentation into the adjoining wetlands on your projects. And these projects had consistent repeat discharges every time it rained. And it was silly things. I would go out, the erosion control was still in disrepair. And it was months of this, months of going out, hey, you gotta fix this, hey, this is your permit, hey, you gotta fix this, leading up to violation letters, leading up to enforcement orders, and never actually getting resolution on it. Something like having the ability to issue a fine at that point gets someone's attention. It's not just, oh no, Michelle's on my construction site being a nag again, it's, wow, I don't wanna have to pay these fines, I need to do something to stop this.
And you can do something probably with less money than the fine would cost.
But you said yourself, those occurrences are few and far between.
They are.
And so you feel it necessary to make a broad-based penalty system across the board in the bylaw?
It's the only way you can do it.
There's no way to do it, just say, oh, well, we're only gonna fine developers,
I
you
thought-
can't
I
legally
thought
do
if
that.
it were so bad, Michelle, I thought you as the town could take them to DEP for enforcement, is that correct?
So yes, the commission can and has, on both of those cases, enforcement orders were issued. They're issued under the Wetlands Protection Act. For those of you who don't know, the Conservation Commission at the local level and Mass DEP have at the state level, have joint jurisdiction over the Wetlands Protection Act. So I issue an enforcement order, right up there, everything that's been going on, what all the problems are, include pictures, all the details. And it gets sent to the state. Mass DEP gets a copy. Typically, Mass DEP doesn't reach out. I assume they log it. I hope they read it. They don't reach out. We review it in a meeting. We have whoever the violators come and chat about it. A lot of times things get better at that point. If they don't, I will contact Mass DEP directly and I will tell them, hey, we issued this enforcement order. Here's a copy of it. I'm not getting any resolution on this. The commission can't get the site under compliance. Can you come out and assist? And Mass DEP will come out. They'll send someone. We'll come out. We'll walk the site together. And Mass DEP, in my experience, will say, wow, Michelle and Conservation Commission, you're right, the site is a problem. These are major impacts to wetland resource areas. The site is not under control. Contractor, applicant, whomever. These are the steps you need to do to fix it. If you don't, Mass DEP can issue criminal and civil penalties. Their fines are up to $25,000 per day per violation. And that's where it stops. I have had Mass DEP tell me to my face that they don't have the bandwidth to take on these enforcement cases, but I'm doing a good job. But those cases were never resolved. So this gives the commission something. We've brought in Mass DEP, we're still not getting resolution. Now the commission can start finding at a local level to try to get these sites under control quicker. Because the longer they're out of control, the more impacts are happening to wetlands that whole time. That's how it typically goes today and how a fine would hopefully help avoid it.
Yeah, and if like the building inspector found something out of compliance, I mean, I think litigation is a huge step, whereas a fine is like something in between.
And a fine helps the case, if God forbid the commission had to litigate for someone, because we can today under the Wetlands Protection Act, with the approval of select board, we could enter litigation against someone that's violating. If we have a bylaw that allows us to issue fines, it's another layer to show, look, we've tried all of these smaller steps to get this person to get the site under control, and they're still not doing it. It makes a stronger case if it does have to go to litigation.
So you would agree that going to court is a costly and lengthy process, is that a correct? statement?
Yeah, I don't think that's something we would wanna do.
Great, so that's a perfect segue into my next question.
Hold on, are we?
Oh, I'm sorry.
I know I have people that are online that have waited patiently and I have comments in the chat, and we can circle back?
Yeah.
All right, Barry, I see your hand up next, and I know you've been waiting patiently.
Thank you very much. Barry Fogel, 4 Upland Lane. I've been practicing environmental law in the wetlands field for 40 years, beginning when I was at Mass DEP when the regulations were adopted in 1984. I've represented clients in front of dozens of conservation commissions. The reason that there are not bylaws or ordinances in every city and town is because they're not necessary. The Western Mass and Central Mass communities that you showed on your figure that don't have bylaws or ordinances are very much like West Newbury. They have wetlands, they have much steeper grades, they have streams, they have ponds. They very adequately regulate wetlands and control and protect wetlands in their communities. Couple of things about your information piece that you circulated. The cost to the community is increased by a bylaw. If you issue a decision that someone doesn't like under the bylaw, whether it's an abutter because they don't like an approval, or an applicant because they didn't like a denial, their recourse is to Superior Court. They do not have the ability to override the decision under the bylaw at DEP. That costs the applicant or the neighbors time and money, and it costs the town of West Newbury town council fees to represent the commission. So it's not an accurate statement to say that adding a bylaw doesn't increase cost to the town. The other comment you have in there, which is the Wetlands Protection Act is 50 years old and the Mass DEP regulations are 40 years old. Those regulations and statute have been changed many times over the last 40 years and 50 years. It's not like they were adopted back then and have never been changed. And so it's not as though we need to somehow bolster or supplement an aging and failing wetlands protection program that's implemented by commissions under the State Wetlands Protection Act. There are some things in the bylaw that I could probably support in a bylaw, and it was on your slide 19 of 20. I don't think it's a bad idea perhaps to have a local bylaw for isolated wetlands, for smaller ponds, for vernal pools. And it might not be a bad idea to protect the inner 50 feet of the 100-foot buffer zone, but you can do that without making it a local resource area. I don't think you need to charge extra fees for under a local bylaw. And if you're gonna have fines, we're gonna have fines, it should state up to $300. It doesn't necessarily have to be $300 a day. It could be an appropriate fine for the appropriate violation if that were the case. Everything else that you're trying to do in this bylaw is unnecessary. I have not seen anything in your materials, whether it's this version of the bylaw or the one that was proposed a couple of years ago, that gave any examples of where wetlands were inappropriately or insufficiently protected because we did not have a local bylaw, other than perhaps isolated wetlands, vernal pools, small ponds, and the like. I was on the Conservation Commission in town for more than a decade, several years ago, and we actually were able to work with proponents to get 25-foot no disturb and 50-foot no build zones included as part of the proposal by negotiation and discussion. It doesn't have to be imposed, and we certainly do not need to expand buffer zones to 200 feet from perennial streams. I do a lot of work in communities where they have followed the crowd because MACC, the Massachusetts Association of Conservation Commission, trotted out a 200-foot buffer zone several years ago, and they have excessive reach onto people's properties. Someone cutting a tree down 185 feet from a stream has no impact on that stream. It's not going to destabilize the bank of that stream, which is the protected resource area of the stream. It's not going to disturb the land under the water body. We have ample protection for streams and wetlands with the 100-foot buffer zone that's available under the State Wetlands Protection Act. Those are just a couple of my thoughts. I plan to attend the town meeting and to oppose this bylaw as drafted. I am more than happy to work with the commission on a streamlined local bylaw that would cover isolated wetlands, small ponds, vernal pools with a reasonable fine authority. But the rest of it is excessive and will only add extreme costs and problems for owners, abutters, and the town through the appeals process that has to go to Superior Court. Thank you.
Thanks. Yeah, Barry, I just have a quick question. I think maybe,
I didn't know what you said. What did you say?
I was just asking if we should speak to the accuracies of those statements.
and that's where I was going with it. Barry, I don't know if maybe one of the slides were misinterpreted, and we have a decent sized audience here too, so I just want to make sure that we're all discussing the bylaw accurately. There is no additional 200-foot buffer zone or around streams proposed in this bylaw. That was
calling it the riverfront.
That is under the Wetlands Protection Act today. It was added in 1995.
So
The
why do
river-
we need a 200-foot local buffer zone?
We're not adding a 200-foot local buffer zone. That slide was acknowledging that today around perennial streams and rivers, there is a 200-foot riverfront resource area. We're
Okay,
not
that-
adding 200 feet around anything.
And that doesn't identify that as a local resource separately.
No,
Okay, that's
it's
fine.
it's just gonna be under the act. I don't mean to call so quickly on that one. I know previously that had a lot of people pretty upset on it. I
Yeah.
just wanna be clear, that's not proposed in this version of the bylaw. I'll turn it over to Molly if she wants to address
Well,
anything
that's
else.
great. It's good to know.
Thanks, Barry.
One of the reasons we want to codify the 100-foot buffer zone as a resource area is because I think that there's been ways for people to get around the 25-foot no build, the 25-foot no disturb, 50-foot no build policies that, yes, can be negotiated with some people, but maybe not with everyone. And we have no way to make that consistent at the moment. So
Well, that's
some
a
people,
good point. But you could in a bylaw just create a 25-foot no build, no disturb buffer. And it's 50.
Yes.
You could just do a 25 and a 50 and just make that part of the bylaw without
Which
making
is
the
what-
entire 100-foot buffer a resource area.
I don't think that there is a way to address that without making the buffer zone a resource area.
I'd make a new resource area is just the first 50 feet of the
Yeah.
buffer zone, but then there'd be even more numbers people are throwing around getting confused about.
So say, take the whole 100.
Again, it's a question of how many extra nuances do we want to add, or how can we simplify? Just difficult sometimes.
It is difficult, and I think, what we are trying to propose is, without getting too far into regulations, is exactly how the Conservation Commission has done things or hoped to do things over the years. But there's no way to make that consistent and to make it fair for every applicant.
Well, it raises one thing, it raises a good point that you've got in here that you would adopt the standards for that in regulations. And one of the problem with kicking that down the road to regulations is you go through a public process, you adopt the rules. The
Mhm.
town, through town meeting, couldn't change, you'd have to go through town meeting to change the bylaw to take that away. And so if you're going to establish standards for buffer zone work, put that in a bylaw. Don't make that part of regulations that people don't see now or won't see when they're deciding whether to support a bylaw. That's a concern I have about the way the bylaw is drafted as well. You know the section I'm speaking of?
Mhm.
I have one more person in Zoom with their hand up, and then I know there's a bunch of comments and questions that have come through in the chat. Maybe we'll take this hand that's up and then I can read through in the chat and see if there's anything we haven't already addressed. Sure. Graham, if you have your hand up, if you wanna go now or listening.
I'll go now. All right, sorry, I want to get the dog in. All right, so what I was looking for with this is that what is the elevator speech in a sense, the 40,000-foot view? What is this bylaw and what isn't this bylaw? If you were just to explain it to somebody quickly on the street, how would you explain it to them?
You want it?
Well, as we've said, I think a previous question was why is this so complicated? Why does it take 5 hours to read this for someone who's worked in town for many, many years? It is complicated, and I feel like it's hard to give a 40,000-foot view of it without going into more granular detail, without leaving something out.
I can give my best shot.
Yeah.
Say, I've elevator pitched it to people before. So the proposed bylaw fills in some gaps that the commission's highlighted in the slideshow tonight about where there's limited or no protections for certain resource areas today. So namely vernal pools, smaller isolated wetlands, smaller ponds, and not being able to regulate consistently that area in that 100-foot buffer zone. So having this bylaw gives the commission the ability to regulate those areas consistently under the bylaw, create regulations. Everyone's gonna play from the same playbook. I think Molly spoke a little bit earlier about how there's some inconsistencies. A homeowner proposing a garage, 13 feet off the wetlands probably doesn't know when the commission says, hey, we like to see that 25 feet off the wetlands, that that's not a lot, and that they can really push hard on that. Developers do know that, and we've had some projects come in with, houses 15 feet off the edge of wetlands. So I think that's the big greater piece of community control there. And then those additional resource area values, recognizing beyond the 8 interests that the act protects, that wetlands provide this community with additional resource area values. So some of those are recreation, agriculture, rare species habitat. So being able to protect and consider those important values when the commission permits projects in wetlands. Because right now the commission isn't able to look at those as some of the benefits that wetlands provide the community when they go through permitting. My elevator speech.
That's
Anything
good.
else?
That's good.
Till you just leave. Molly, I'll defer to you on order here. I think Nancy has her hand up now, but a moment ago I said I'd read through the chat. Do you want to do chat then Nancy, or Nancy then chat?
Let's do Nancy and then chat.
Nancy then chat. Oh, and Nancy's gone.
Okay.
No,
Sorry, Nancy. Oh, no,
There you are. Nancy.
Hi, everyone. Thank you for having this info session and try. I know it's really hard to explain this because the Wetland Protection Act is very complicated. And I do appreciate that we do need a bylaw. And I think the most important part of this bylaw is the fine, so that, you know, when someone willfully disregard the regulations, there is a consequence, which, you know, I know it doesn't exist now. So I am in full support of that. And I think another good job that you guys have done is take very complicated legalese, that's like 300 and some odd pages of state regulations, and try to put it in common language. I know it's still hard for people to understand, but you have improved it a lot. I guess 2 things I kind of want to mention, and I know you've heard from me previously, so I won't get too detailed. The vernal pool changes, as I understand it, if it's a certified vernal pool, the state law currently does provide a 100-foot buffer around that certified vernal pool, and there is protection. And I wanted to make sure that I understood that correctly. What concerns me with the bylaw, and maybe just more detail in the bylaw, is the language about assuming that it is a vernal pool when it's not certified, and how do you define what isolated wetlands is a vernal pool? And then a second part of my question or suggestion is, you know, I think everyone is concerned about stormwater and increased flooding. And I think in West Newbury, we're kind of lucky in that we can still, as you mentioned, wetlands is an amazing solution to stormwater management going forward. And West Newbury is unique in the North Shore towns in that we have intact systems where landowners can actually build vegetated swales, ponds, versus more engineered solutions to do that. And they tend to be more resilient and adaptable. I'm wondering if you would consider putting in the exemptions constructed wetlands for the purpose, or ponds or swales for the purpose of stormwater management, exempt that from regulations. My concern is that, you know, if those are considered wetlands and you put a 100-foot buffer around that, that could become somebody's entire property, including the house, and that would deter people from using more natural, nature-based solutions for stormwater protection and go towards, like, you know, French drains or other engineered solutions that we know that are not going to be as resilient in the future and is not as good for nature and adjacent wetlands.
Thanks, Nancy. Do you want me to go on that vernal pool one?
With a couple of things.
Yeah,
I
from my understanding, vernal pools, if they're not connected to another resource area, they do not have any buffer zone whatsoever.
Yes, so Nancy, what Molly was saying is correct. So the Wetlands Protection Act recognizes around certified vernal pools only, so those certified through the state's Natural Heritage and Endangered Species Program, 100-foot buffer zone only to the extent that it overlaps with another resource area, and because the buffer zone is not a resource area under the Wetlands Protection Act, if that it's not a resource area. So if you had a vernal pool and the vernal pool is half in a wetland, half not in a wetland, right, as sometimes they are, it's a depression in the wetland itself, maybe half in, half out. Only the 100-foot buffer zone that extends into that wetland is protected under the State Wetlands Protection Act. So 100-foot buffer zone on the other side in the upland where there is no wetland isn't protected. And, you know, as we explained in our slideshow, a lot of the obligate species of vernal pools need that upland area. They need to get into woody debris, down trees, under leaves. That's where they spend the majority of their lives. So right now that 100-foot buffer on the upland side doesn't exist under the Wetlands Protection Act.
And then storm structures are,
Yeah, oh, I had one more on the vernal pool, language assuming is, okay. So the definition section in the bylaw includes the provisions for determining if an isolated wetland is a vernal pool without state certification. And it's similar to the state certification process where the commission's looking at biological evidence of obligate vernal pool species. So a puddle that never has, you know, egg masses of wood frogs or spotted salamanders wouldn't automatically become a vernal pool. It would need to have that vernal pool creature activity in it. And then, all right, that was the last vernal pool one I had.
right, and then storm structures are already exempt.
Yes, yes and no.
Yeah.
So the Wetlands Protection Act, and because we don't define it differently, it would be exempt under the bylaw as well. Any structure that was created for stormwater, to say a housing development that has a detention basin that was put in 2001. That's not a wetland today. It won't be a wetland under this bylaw. That's not going to change. It's a stormwater structure. I think, Nancy, you were talking about maybe excavating an area adjacent to a wetland to build some capacity for stormwater. I don't think the commission can exempt that in their bylaw, because if that excavation was happening in the buffer zone of a wetland, or there's a swale being constructed towards the wetland, that is regulated today under the Wetlands Protection Act. So the commission can't make an exemption that's less strict than the act to construct something like that in the buffer zone. I don't know if that.
Yeah, I think my question was if you were to construct something that's outside the buffer zone, but it meets the criteria of the wetland, you know, the 5,000 square feet, you know, whether that's a vegetated swale or
Got it.
For water storage, or, you know, is there a way to exempt those when the purpose? Yeah, I think detention basins, most people don't look at them as wetlands because they don't really function as wetlands. But I think a lot of the more natural storm protection solutions that's coming out now, they are built to more function like wetlands, and might kind of meet the criteria of wetlands. So
I got it.
yeah, just making sure that you know, detention basin and all the kind of more the new nature-based stormwater solutions that's coming out now are also included in those exemptions.
Yep, they would be. So it's a stormwater structure, whether, you know, it's a detention basin or a pocket wetland or a rain garden or bio-infiltration basin. And we have a lot of projects in town that do have those. If it's shown on plans as managing stormwater, it's exempt today from being considered a wetland under the Wetlands Protection Act. It would be exempt from being considered a wetland under the bylaw. So some examples of those are the new development on Deer Run coming in on the right-hand side. There's a constructed wetland for stormwater management. The new high school has bio-infiltration basins. Those are all stormwater management structures and not wetlands.
Thank you.
All right, chat, read through the chat.
Yeah.
So the first one I have is from Camden. Could you clarify and expand on what activities are excluded in the buffer zone? There's a
It's
whole,
a long list.
there's a list in the Wetlands Protection Act. Camden, if you want to send me an email, I will send you the reference to where you can find that list in the Wetlands Protection Act, because that's the exemptions that'll be recognized in this bylaw. I'll put my email address in the chat. Can't spell Excel, so that's not helping us. Okay, let's see. Can we alternate, or we didn't do that, sorry about that, Barry. Section 6.8 is not clearly defined, it's from Manuel Sanchez Felix. It can be interpreted many ways, it needs to be more specific to the examples provided. He also added that in May, the Supreme Court ruled that the Clean Water Act does not cover wetlands that lack a continuous surface connection to a larger body of water and exclude from protection ephemeral streams that flow only seasonally. Are these ephemeral streams excluded from the Wetlands Protection Bylaw? Do you want?
So in section 6.8, we're talking about consultants.
Consultants.
And again, I think Michelle talked a little bit about this being projects that are complex or large. This wouldn't be, you know, a single homeowner necessarily. This could be, you know, a subdivision or a shared driveway that might require wetlands replication. We need, in those circumstances, we're a volunteer board. We're not necessarily going to make decisions on something that is so large and complex without help from a consultant.
And then regarding the Supreme Court decision, Massachusetts is a little bit different. We have the Wetlands Protection Act as a state law, so it does protect ephemeral streams. They use the word ephemeral. It essentially means intermittent. It's not year-round flowing. When you say ephemeral, it usually only applies to spring, so they could probably maybe update a definition there. But anyways, it's a stream that's not flowing year-round, not a perennial stream, not a river. That's an ephemeral stream. Those are protected today under the State Wetlands Protection Act. So even with the Supreme Court ruling, they'll remain protected. And they'll be protected the same way under the bylaw if it were to be adopted. It is interesting with the Supreme Court decision. It would impact isolated wetlands that don't currently meet the size threshold of the Wetlands Protection Act. So this bylaw, and I am not an attorney, but if my understanding is that this bylaw would give protections to those non-connected to surface water isolated wetlands that are smaller than what the State Wetlands Protection Act, if we were to protect them locally. I don't know if that,
I think the
clarified.
Supreme Court made a lot of decisions in the last year and none of them are relevant to this bylaw.
that's, yeah, where you have the Massachusetts State Wetlands Protection Act, it's stronger than, you know, states that don't have state wetlands protection laws. Let's see. I have another question from Barry. The commission has still not provided any examples of the need for this bylaw in West Newbury. The fact that other municipalities have them is not a reason to do this. A much more streamlined bylaw can be drafted that would cover small ponds, vernal pools, the inner buffer zone, etc. I don't know if you want to address that any further.
Yeah, I think.
I wrote that before I was able to speak.
Thank you for clarifying. I have another comment from Manuel Sanchez Felix. Section 6.8 is the main concern that this can have a major impact on all residents in West Newbury who probably all live within 100 feet of a wetland. This could be interpreted as all residents can fall under this and end up having to spend $10,000 to $100,000 on a decision by the town. It needs to be modified. I'll stop there because it goes into different questions. Again, section 6.8 is just the policy that exists today of the commission. If the commission finds today that they have filing for a large and complex project, they can require a third-party consultant to provide peer review. We have
happened maybe twice in the last 5 or 6 years.
We have one project currently with that, and the project involves multiple wetlands crossings and replication. So we have a third-party peer reviewer on it to confirm that the edge of the wetlands is correct as shown on the plans, but also the areas that the replications are proposed in will hydrologically support creating replicated wetlands. So that's a little bit more involved than what a volunteer board can pull up when doing a review. That's when that would apply.
I'm wondering if this question has to do with consultants being engineers.
I don't know. Manuel, if we missed anything, if you want to raise your hand, we can have more conversation on that. Then there's a question, when is the bylaw going to be voted on in the town? So that's the Springtown meeting, April 29th, 7 PM in the Town Hall Annex Building. Again, section 6.8 is not clear, needs to be changed. I think we've addressed that. Barry again, sorry, Barry, you had a couple comments in there. Ross answered when town meeting was. That's my email. We have a new comment from Barry. The definition of alteration includes destruction of plant life, including but not limited to cutting or trimming of trees, shrubs, and other vegetation. This conflicts with the exemption for routine mowing and maintenance of lawns, gardens, and landscaped areas.
Doesn't, because the exemption is an exemption.
I would tend to agree with that, that an exemption is an exemption. So if it's an exempt activity, it doesn't need permitting for the destruction of plant life.
Michelle, if I could on that. So the problem is that it says including but not limited to. So all you're exempting is routine mowing of lawns. No one's going to mow a garden or landscaped areas and maintenance of that. So presumably you can cut or trim shrubs in a landscaped area, but you can't trim a branch off of a tree. You can't remove a shrub from outside of a landscaped area. I just would urge you to take a close look and make sure, because I think there's plenty of room for the definition of alteration that you've got here to conflict with that exemption and will create problems if this were to be adopted this way.
Thanks, Barry. We can take a look at that. I think the commission expanded on this for clarity. It aligns pretty closely with the definition, at least for destruction of plant life in the act. So the Wetlands Protection Act regulations list alteration as a definition with examples, and destruction of plant life period is an example of a activity that needs a filing. So I think we were trying to expand on that a little bit.
The DEP regs have minor activity exemptions in the buffer zone 1002. So there's places
We
where
adopted those as well.
Those
Yeah,
are all continue to be exempt.
if this were to happen, I think you just have to make sure that this is local, not the state, but you've got two things that I think could be a potential conflict between the way the exemption's written. You can shake your head.
It's not a conflict, it's an exemption. By definition, an exemption exempts you from the alteration
All right,
consideration.
let me state it this way. If this were to pass, you're only exempting very little, and there's a lot more work that would go on in buffer zone that people in the community might want to do to cut or trim vegetation that won't be considered exempt. And that's where the problem is. The exemption may be too narrow for all the things that people could and should be able to do.
I think what David was trying to say is those activities aren't exempt today under the Wetlands Protection Act unless they fall into that narrow exempted activities section.
But
And we
in the
could make it
DEP regs, it only is subject to jurisdiction if it's going to alter the resource area next to it. By you making the buffer zone a resource area, you're now prohibiting a lot of cutting or trimming of vegetation that under the DEP regulations would not be subject to jurisdiction because it would not have a cause an alteration of the adjacent resource area. That's the difference between having a buffer zone that's a buffer zone, the way it's written in the DEP rules, and having a buffer zone be a resource area. You're grabbing a lot more activity in the buffer zone that DEP does not regulate and conservation commissions don't regulate, because of that aspect of what's regulated in the buffer zone and the DEP rules is if it would alter or have an adverse effect on the adjacent resource area. That's the critical difference.
I hear you on that, but the commission has to make that determination. So today, if someone wanted to cut down trees in the buffer zone, they would have to file a request for determination of applicability, and the commission would make the determination if the removal of those trees would alter an adjacent wetland resource area. Do you agree with that interpretation? That's how it's been administered.
Right. Not only do I agree with it, but that makes my point of how the DEP regulations adequately regulate activity in the buffer zone, and we don't have a need for a bylaw to double down on that exact thing. What you just said is exactly the way it's done today, and it works perfectly.
And there would be no change in that example. So that same request for determination of applicability form would be submitted. There's a section when the commission makes its determination to determine if that activity is going to alter a resource area under the State Wetlands Protection Act. And if the commission has a bylaw, there's a section for the commission to make a determination of if that activity will alter an area subject to protection under a bylaw. Even though the resource area is it being expanded potentially in this bylaw to include buffer zone, I think the commission would still find that removing 3 or 4 hazardous trees out of the buffer zone isn't going to alter that area. It's not going to impact it. So it would still proceed with a negative determination of applicability. The proponent of that work could still cut down those trees without any additional filing.
Except
I think I see.
you've defined the buffer zone as a resource area. So
Yes.
in your definition of alteration, where the bylaw is drafted says includes the following activities when undertaken to, upon, within, or affecting resource areas, cutting a tree in the local bylaw or buffer zone would be affecting it. It might not affect the adjacent wetland or stream bank today. So today you could give a negative determination of applicability and say that won't affect the resource area. You'd be hard pressed to say that it won't affect the buffer zone itself if you make it a resource area. And even if you did do that, the neighbor might decide to not like their neighbor and appeal that. Where? Superior Court. So, it's creating a potential for unintended consequences by turning the buffer zone today that protects the adjacent resource area into its own resource area. And you have to, with a fine-tooth comb, go through these definitions and exemptions to see where's the mischief going to come up. That's one of my concerns on that one.
Yeah, I hear you. I mean, I don't know. I'm trying to think of it in real world example terms, and you can tell me if you think I'm missing the mark again. We permit tree removal in the riverfront resource area, right? So essentially the 200-foot buffer around rivers, the state calls it a resource area. We permit those with negative determinations of applicability today under the State Wetlands Protection Act that says destruction of plant life is an alteration. And you're able to permit it. The RDA, or the determination of applicability form, when the commission issues it, gives the option for the commission to select that the activity is in a resource area. So in that example, 200-foot riverfront resource area, it's a resource area today, but will not alter that area. And I think this commission has found, and Mass DEP hasn't ever intervened with a superseding order of conditions on these determinations. I think that they agree that the cutting of a few trees in the riverfront resource area is not altering it. I think if someone was clear cutting the riverfront resource area, well, that would be a positive determination. I do think the forms exist today in a way to not require additional permitting, even with the way terms are defined in this bylaw, even with changing the buffer zone to a resource area.
I'd have to check, Michelle, but I think that riverfront language is won't have an adverse effect, not won't alter. And that's where you also get into a really dicey kind of slippery slope that alter and having an adverse effect is probably where the rubber meets the road in wetlands protection. And so I'd have to check the riverfront regs to see if it says can be allowed if it won't alter, or if it says won't have an adverse impact. But
yeah,
you're right. I mean, you're honing in on, I mean, most of the people in the community don't know what you know and what the commissioners know and the stuff. And so I'm coming at it from the standpoint of when I'm in front of a conservation commission, either for an applicant or an abutter, this is where the decisions get made on these definitions of alter and adverse impact and significant adverse impact and all that kind of, the stuff that Mr. and Mrs. Smith who want to put a deck on the back of their house, their heads are going to spin, right? So I'm just trying to watch for traps and for you guys and for the community. And that's where this one sort of jumped out. We don't have to spend any more time on it.
Yeah, and we can run this by with, the town's legal counsel to make sure that they see it, that with these definitions, the commission can apply as we just explained in that example, because the commission's intent here isn't to have a trap where someone, you know, comes in to cut down a couple trees in the buffer zone. The commission issues a positive determination because buffer zone's a resource area, and then the commission requires them to file a notice of intent. That's not the goal here, so I'll have legal counsel check that again and make sure that they see it the way that we're seeing it, that we could still issue a negative determination of applicability like we can today.
Until the abutter who's unhappy with their neighbor makes mischief with it. And maybe you guys may be reasonable, the next commission may not be, the next commission administrator or agent may not be, and the bylaw is sitting there creating another mechanism for people to make mischief.
Understood. I have another question in the chat. Section 6.8 simply implements an existing state law that allows Concom to require applicants to pay reasonable fees for peer review for complex projects. This is not likely to be used for simple or standard projects, and very little in West Newbury would require an expert that has skills or expertise that the commission or the agent does not have. I think we've gone over that in detail. I think Barry's comment speaks to the examples that the commission and myself provided.
Michelle, I personally have been on the commission for less than 2 years. Only just recently have we engaged a peer review consultant for a project involving a subdivision. We haven't done it in any other time that I've been.
I've been here for 3 years and we haven't, and it's not typical. And the subdivision, like I said, it's crossing wetlands, it's filling wetlands, and it's proposing to replicate wetlands. So it's pretty complex, and it needs to get done right if those wetlands replications are gonna be successful.
And, you know, and the idea is to protect the neighbors around a very complex project. You know, we don't want that to get done, and neighbors have repercussions because water hasn't been properly taken care of.
There was some personal correspondence there, so I just skimmed through it unless Barry or Manuel, you want me to go into detail on anything. Nancy Powell added that the Supreme Court ruling impacts Federal Clean Water Act. It doesn't impact the State Wetlands Protection Act, which delegate to the town's Conservation Commission. Yes, that is correct. Dan Innes, has anyone addressed the cost to the town to enforce this proposed bylaw? Apologies if this has been addressed, I came on late. In a roundabout way, I don't think so. Dan, I don't know if you want to speak up. In what manner are you asking this question? Hey there.
So, hey, hopefully you can hear me.
Yep.
Michelle, I've listened on and off, and a lot of questions have come up, and there's just a lot of details that are written into the bylaws that need to be enforced. And there's got to be, I think Barry said it earlier, there's going to be a cost to the town, but what's the estimate of that, what that's going to be? And that's where, if anybody's done that, if you've looked at it, how many more hours of your time are going to be spent enforcing these additional bylaws? And what's going to be the benefit to the town to have you do that? I mean, you're busy as it is. Is this going to require additional resources? You're going to have to outsource it. How do we look at that? And, you know, I'm asking from, you know, being a resident in town, but also from the FinCom perspective. How would you be able to answer that for us?
Do you want me to? Sure. Yeah, so, you know, I think I don't know if you were on, we talked about what are the big differences between this bylaw and the resource areas that are protected under it in the state act. So yes, the bylaw proposes to treat buffer zone as a resource area, but let's cut that out of the equation for this a second, because right now today, any activity that's happening in buffer zone, if it's in violation of the Wetlands Protection Act, right, proceeding without a permit, my time's being spent addressing it. So that time's already in the mix today. So there's really 3 additional resource areas that right now aren't protected under the bylaw, under the act that we're adding in the bylaw. It's ponds between the sizes of 5,000 square feet and 10,000 square feet, because that's where the State Wetlands Protection Act picks up. It's isolated wetlands of at least 5,000 square feet, and it's vernal pools, and vernal pools that aren't getting any protections under the state today. You know, you might have heard us, or maybe you came on a little bit late. There's not a lot of those resource areas in the town. We did a mapping review for the small ponds, for example. I think we came up with 6 or 7 of them. As far as vernal pools, there's about a dozen throughout the town. A lot of those vernal pools exist on, not private land that's not gonna be developed, protected land, tree and wildlife management area, River Road Reservation. So I don't see that making an increase in my time. So these violations are happening today. I spend my time issuing enforcement orders and violation letters and talking to people today. It's the same amount of time. I will just be adding that, hey, this is also a violation of the Wetlands Protection Bylaw at the local level, in addition to the state act. And all of the wetlands permitting forms that we've been discussing, they're already created for a conservation commission to approve a project simultaneously under an act and a local bylaw. So there's not a creation of a new permitting form. I'm not issuing out 2 permits on every project. So in those regards, I don't see the enforcement of the bylaw taking a huge amount of my time. I think education will continue to take a lot of my time, as it does today, honestly. I talk to a lot of people and they're not familiar with the Wetlands Protection Act. So again, it's another example of, we're gonna be talking already, we're gonna be talking about the Wetlands Protection Act and the bylaw at the same time. So I don't see those impacts to my time greatly increasing.
Okay, thank you for the answer.
Yeah. I got a couple more questions. So just more question or feedback on section 6.8. I feel like the commission's addressed, the situations when the commission would engage a consultant. That catches us up on the chat and in the Zoom.
Are you gonna open the floor for additional questions here?
Yeah, we're caught up, so, yeah.
Great, okay. So I talked about the side-by-side comparison. Again, when it comes before the town, people need to be able to see, okay, what is the state? What are you proposing? What are the differences? Okay. Okay. The resource area, so my understanding, so currently, if you're within 100 foot and trying to operate within the 100-foot buffer zone, that falls under the jurisdiction of the Conservation Commission. And so you can build in the buffer zone, but you require an order of conditions, and with that order of conditions, you tell me if you do A, B, C, and D, that you can build here, provided you provide protection, whether it be siltation barriers, all of those different regulations. Under the resource area, what would be the difference? Is it a no build area? Is that what you're telling us? Under the resource?
Those have been policies that the Conservation Commission has had for many years, the 25-foot no disturb area.
But
And
it is a resource area. Can you build within any area of the 100-foot resource area?
Yes.
Does it say that in the bylaw?
No, and in my opinion, it doesn't have to. We can agree to disagree on that. So what you'll see is in the regulations, and the bylaw in the section on regulations makes reference to that in those regulations, the commission will do all sorts of things. It'll redefine definitions, it'll do all of the things. But one thing that it points out is that it will also include naturally vegetated, undisturbed areas around resource areas. That's where you're getting into the commission making the buffer zone a resource area so that within that 100-foot buffer zone, they can create and codify 25-foot no disturb and 50-foot no build with waiver provisions. We've talked about this already in public meeting. West Newbury doesn't have sewers, someone's septic system fails. The only place they get parks or can put a septic system is 15 feet off the edge of the wetland. The commission's gonna grant a waiver for that. The commission's gonna say, hey, you have to abandon your house because you don't have a septic system. It's
Problem is, I don't see any of that in there.
because those are in regulations and not bylaws. The regulations discuss how you will apply the bylaw, just like the regulations of the act explain how you apply the act.
So, I think like Darren mentioned, we've had many, many different commissions over my 40+ years here. And some have been more reasonable to work with from the homeowner's perspective than others. And one of the big things that I have a big problem with is that you are proposing taking away, if the Conservation Commission comes before the board and I propose to do particular work, and you say, you know what, we don't agree with you and we're not gonna allow you to do the work. right now, as you're proposing it, you've taken away my right to appeal to DEP for a superseding order. And I can tell you several projects we've been involved with in the town over the last 40 years that have superseding orders because the Conservation Commission, maybe you folks are the most reasonable people that's out there, but your people who come after you may not be as reasonable as you are. If we have this bylaw as amended, you've taken away that right. Who would support taking away somebody's right to appeal to the state versus having to go to Superior Court? It puts an undue cost and burden on the homeowner. I cannot understand or support that. And I question the selectmen. I mean, do you think that's in the best interest of the residents of the town? Wendy, Rick, what are your thoughts?
This is the Conservation Commission's information session. If you would like to come to the select board meeting, we can discuss that.
I'm just curious.
Well, and the select board is also in charge of appointing conservation commission members. If there's a slew of unreasonable conservation commission members, the select board is ultimately responsible for making sure that that doesn't happen.
But that doesn't address, why are we taking away somebody's right of appeal to the state?
Can I,
That's a
Madam Chair? I want to make a clarification for the gentleman, which is you haven't lost the right to appeal to DEP for the portions of the decision under the state regulations. The only part that would have to go to Superior Court is if any part of the decision is unique to something that's more stringent in the local bylaw. And here, A, that could be just the 100-foot buffer zone itself. B, it could be something that's adopted in the regulations that none of us will have seen before this vote. So, you know, there is that split. You may have to take 2 appeals, which is the other portion of that. The other thing I want to point out is that during my tenure on the Conservation Commission, the Select Board actually reduced the number of members on the Conservation Commission in order to get rid of 2 members whose terms were coming up, who did the most work and worked the hardest to enforce the State Wetlands Protection Act. So it can cut both ways. You can knock people off who are doing a great job, or you can pack the commission with people who are going to look the other way. And, you know, unfortunately, because of that uncertainty, some of these traps in a bylaw, and I see it in other communities. I cannot tell you how often I've been involved in a case where an abutter takes an appeal to Superior Court and over something very odd in the bylaw or the local ordinance that has nothing to do, frankly, with that project and its impacts on wetlands. It can kill a project, it can delay a project, it can add costs to the community.
Under 3.4, it talks about lawful permission, about trimming, cutting, maintaining these areas. What defines lawful permission?
I think we talked about that before.
And I think we're going that lawful is talking about that those areas were created lawfully. So if you went home today and you bulldozed a bunch of fill into a wetland and planted some grass seed and then started mowing it in June, that's not a lawfully created lawn.
But, okay, so take that a step backwards then.
Yeah.
So you've got all of these properties within the town, and as we talked about earlier, you've got a lot of clay soil here, which holds the water, retains the water. So there's lots of properties with fields, pastures, whatever, that have been mowed for not only 50, 100 years, but generations.
Yeah.
And was that lawfully created?
Yes.
Because they existed pre-Wetlands Protection Act, so at the time it was lawful that those areas were pastured. Some of those areas were filled wetlands.
But we also agree that wetlands change over years
Yeah.
and time. So what if wetlands have migrated since then? Does that give the commission the right to come forward and say, well, we realized when you did this that wasn't there, but things have changed and now you can no longer maintain this.
No, that's exactly why we have this exception in there, is for that, so that if the wetlands move and if we were delaying this today, it'd be right in the middle of your pool. Like, we can't touch that, and this is protected. Like, we put a lot of things in here to protect people from that kind of thing.
And I think everybody's intent, just so you know, everybody's intent, we all want to protect things, right?
But there's no, my hands are tied, or our hands are tied as far as what we can do. We can't be less restrictive than the act. And
No one wants
most
to be.
people don't really even understand how potentially invasive the act can be, right? And I don't like it necessarily, but like, that's where it is, right? We've tried to make as much discretionary as possible, because you don't want like absolute must have, like the fines are all, we can vacate them, we can delay them. Like we put in a lot of things to allow the fines not to happen, but we can't say up to 300, we have to say 300 according to the lawyers, like.
That
there-
actually came from legal counsel.
There are things like this that we
But
don't
the
have
problem
options
is-
for.
That could potentially get into a personal situation, right? If you have personal issues with somebody.
Well, that's why we have a board, right?
Yeah.
Instead of one person, we don't have a commissioner, we have a commission.
Yeah, and
And
if you're in a butter, you have to
But
recuse
it's
yourself.
that's how town
Right.
government works. I like,
But it's still
It's
discretionary.
still discretionary.
and
But
I think that's in the best interest of the town. If it wasn't discretionary, I think you'd have a lot of harsh decisions that have to be made.
And I guess to just add one thing on discretionary, the edge of wetlands is only so discretionary because it's a scientifically based decision. You know, so we might disagree, maybe a consultant comes in and we're like, oh, this flag should be moved 5 or 6 feet. But at the end of the day, the wetlands are where the wetlands are, and they do change over time. I think that's a great point. So something like a 25-foot no disturb, it's protecting residents of this town in the future. We're seeing it today where there's projects that were built pre-Wetlands Protection Act, or maybe they were permitted in the 1980s, you know, only a few years into the Wetlands Protection Act. And now with our changing climate, we're having culverts that get blown out because there's no capacity to handle that volume of water. We have houses that have lost their backyard because the wetlands that maybe weren't delineated so good back in 1980s when they were delineated have fully expanded to hold water, and now they have no backyard. So having these, you know, maybe it seems arbitrary right now, maybe it seems overly restrictive. I think the commission is not going to be overly restrictive. The regulations will have waiver provisions, but it's not allowing someone to put a house 10 feet off a wetland is really looking out for the future inhabitants of that house 50 years from now, looking at the climate projections, looking at the precipitation projections. That foundation would be in the wetland in the future. So it's trying to prevent that, because that has a cost to the whole community, not just the person living there.
So, and in my period of time in doing this, I've been involved in many situations over 40 years, where residents will come before the board and the Conservation Commission will not approve what they're proposing to do. At that point, the landowner homeowner had a lot less restrictive choice of relief, and then they could actually file for an appeal, and we've done that. River Meadow and several of those are superseding orders. Twig Rush, many of those were superseding orders. Hilltop Circle, Robin Road, Donovan Drive, Woodcrest. I mean, I can go on and on and on. So these were superseding orders. The way you have this proposed now is that you have to go to court.
The other thing is, we're not allowed to have a bylaw that allows you to appeal to DP. DP has said they don't want anything to do with, because they don't want to know what the local laws are in every single community.
That don't have a bylaw. So you really, this articulate woman here, the nurse who talked before, how about the protection of the townspeople?
I think that's what the commission is trying to do with the
By limiting their right of appeal, I don't know how anybody can support that.
I think Barry brought up a good point that if a project was denied today, under the bylaw, if the bylaw is adopted and it's denied, a project is denied, the commission denies it, and there's no findings that differ between the commission's bylaw and the State Wetlands Protection Act, it would still be appealable to Mass DEP.
But anything under the bylaw can't be appealed to DEP.
If
the bylaw were to pass
yep,
as proposed, or some version thereof, then you couldn't appeal that to DEP, you'd have to go to court.
it's only if the commission is making findings that are different under the bylaw than the findings under Mass DEP. So the commission can make a finding today, as it does, that 10 feet, having a house 10 feet off a wetland is going to impact that resource area, right? You're gonna mow around it, you're gonna encroach, you have impervious area close against it. That's a finding that isn't going to change underneath the bylaw if it was to be adopted, and that could still be appealed to Mass DEP. If the commission found that that house 10 feet off the wetland is going to impact the recreational values of that wetland, right? Recreation is not a protected interest under the Wetlands Protection Act. The bird watchers look at the pond from the other side, now there's a house as a backdrop instead of a field, and they don't like it, and we think that we can't approve this project because we're taking away that recreational value. Then yes, you're correct, the proponent of that project would have to appeal that to Superior Court because it is different than the Wetlands Protection Act. You are correct, yep. I think I have chats going on. So I have a comment from Barry in response to Dan Annis's conversation about the cost. Barry states, I believe it will cost taxpayer money to hire town council to defend appeals in Superior Court of decisions issued under the local bylaw. And then Barry Fogel also added, many local bylaws and ordinances have languages authorizing fines up to $300. It can be done and is frequently done. We have that in writing from KP Law that it can't say up to, we have to set a defined number. So they said we could do a $300 fine, or the commission could do a fine schedule, maybe like first offense, $100, second offense, 2, third offense, 3. But they have told us that we can't state up to $300 in our bylaw. Then.
Can you share their opinion with people on that?
It's just, I have no problem sharing that. Yeah, it's just comments on one of our red line documents.
Okay.
Send me, Barry, I don't think I have your email address. Send me a note. I put my email address in the chat and I'll send you that.
Yeah, I wonder if that's based on some case law or if they're just advising that it's, I'll call it easier.
Yeah, got it. I don't know.
So.
And then Barry goes on to say, this is a function of MACC, Mass Association of Conservation Commission, promoting local bylaws as a way to stymie activities and expand jurisdiction based on generalized wetland science that buffers are good, and Alchemy believes that bigger buffers are better. I think we have a slide that talks about it, and there is proof that bigger buffers are better. Naturally vegetated area around a wetland is slowing the water that's coming into it. It's capturing sediment and pollution and nutrients preventing to go in it. It's providing more wildlife habitat. It's storing carbon in the soil. So
And we took the MACC model bylaw and scaled it way back. Yeah. So we're not just doing a boilerplate.
We've really
tailored to West Newbury as best we can.
That's all that I have right now in chat and on Zoom.
One more thing, I guess, the tone of this proposal puts a lot of onus on the homeowner, as I said before, but at every point that you point out that, if it's denied, the burden's on the homeowner, sorry. My husband, who's on there.
He was on. Did you get let back in?
So, he's talking to me now in my pocket. Sorry. Yes, I'm about to say. So yeah, I just at every point that is here, as I pointed out to you, I'm saying I am a simpleton. And knowing the procedure, I think you should do the town a service. When you're in the hospital, there are procedures. And it's not very clear to the homeowner what the procedure is. And our frustration between the two of us, I think particularly has been, you talk in acronyms that we are not familiar with and terminology. And then, there is no clear, if this, then that, if that, then this. A flow chart would be helpful to know when you come up against something, what your next step is as a homeowner. Our situation has been going on a long time, it feels to me. It's exhausting, it's nerve-wracking, and looking at the proposed bylaws, we have, the burden, it says here, the burden of proof is on the homeowner, the burden of increased costs if more scientific experts need to be pulled in, the town will run a tab for you. Thank you very much. There is a whole list of things here that actually take away the right of a landowner to protect the wildlife. And as I said, I think common sense needs to preside. I don't think it's so common anymore. I think there needs to be some compassion, which doesn't seem to exist in this. It's all, you will do this and this will happen and this. It's a very scary proposal for someone who didn't even know they bought a house in a wetland. And, you know, call that my ignorance, but I came out of state from a different state that didn't have so much interest in what was a wetland and what wasn't and what you could do with it. So, you know, I think that you as a town need to do a better job of informing us as to what the procedures are when we are faced with these situations as well, rather than saying, well, let me talk to your engineer, or this is how we're going to do it. And then you think you've done it and you know you haven't. So I think there needs to be some action on your part to show homeowners what the process is, so we can really understand why we're being rejected or being set back to look at it again, and understand why things go the way they go. Because most people are not well informed and understand the language that you even talk in acronyms and what these acts and implications are. So obviously, you can tell I don't approve of most of what's in here, because I think that the balance is missing between, you know, respecting people where they live and the historical aspect of wetlands and housing and how that has come about. There is a historical element that should be grandfathered and acknowledged, that they have existed well before acts and decisions were made by us. So, you know, I think that I speak for those neighbors that don't even know that they're impacted yet. But as you say, wetlands are changing. I think there are many more that are on the tipping point. And, you know, I think this goes way over. It's like a hammer, a sledgehammer to open a nut. It's way too heavy-handed, in my view. Thank you for listening.
If I could just add one note on that. The burden being on the homeowner, I get it, it sounds terrible. That's the burden that exists today under the act. So it's the same as under the act. If you're looking to do work today in a wetland resource area, the burden is on the homeowner to prove that whatever project they're proposing or activity isn't going to impact the resource area. So that's not a new addition, you know, that's unique to this bylaw.
This creates a greater burden. It does. And so the state law is what it is, but this just adds further and greater burden and takes away what we have as an appellate process now before DEP, if this bylaw is approved. And I just wonder, with the people coming to town meeting, are they gonna understand this? I don't think they will.
I think one thing that maybe people don't understand is that the wetlands are a common resource, and incrementally you can do work on your property that maybe you're not aware of the work that's going on around town and what is happening to wetlands. And I think that's why it feels like, you know, this is restricting what you can do on what you're considering your private property. However, the way the water flows through West Newbury is not a private matter, it's a public matter. And I think we're really trying to protect neighbors as well as your rights to do what you want on your land. But sometimes what you do on your land affects other people downstream. And I think it's very hard for people to understand that and to really take that into consideration.
I've not heard anybody address the appeal process part. I mean, we can't appeal this bylaw, so why would we adopt it?
It's been covered.
I don't think it has.
Not to your satisfaction, to your conclusion, but they said you can only appeal to DEP
For the
matters related to the Wetlands Protection Act.
But
Items related to the local, yes, that has been covered. That has been covered.
And I'll point out, that's the same process today. You know, if you wanted to appeal, say, a fine of, I want to water my lawn with my public water, and it's a drought, it's the same process, you appeal it to the court. If the building inspector says, your stairs are too steep, they don't meet the building code, there is no Mass DEP to appeal that decision to, you appeal it to court. So I get it, it's different because under the act, you have been able to appeal to Mass DEP, but all of these other, you know, regulatory schemes, they get appealed to the court. So it's very, when you look at it that way, it's very in line with how it's already worked.
About here though, right? Building code.
It's not really that different, though. It can be a public safety concern if our water supply is,
Contaminated,
Contaminated.
destroyed, lost.
that's a public safety issue. And I know it's hard for you to see as a homeowner, the impact that you might
Just
have.
trying to look big picture too. You don't just look at your own little property, you look big picture as well.
Well, that's what the commission does, and I feel like maybe homeowners don't necessarily see the larger impact on the public resource. And it's a safety, and I don't want my water supply contaminated by work you're doing on, no. Are there any other questions? Thank you all for coming, I really appreciate it.
I have a very practical question.
Yeah.
As you know, the warrant gets posted Monday with a booklet, and so I have the bylaw that was posted. Is there any gonna be any change to it, or is that what you're going with?
Our last meeting before then, so I don't know if the commission is anticipating any changes tonight, but this is the meeting that those changes would be made at.
If you remember, we had talked about how our fee schedule, how it does deviate somewhat
Yeah.
from some of the others where it's begins smaller and it steps up when you don't get the action that you require. And we talked about, based on what we heard tonight and on both media, we may modify that to address concerns, right? And so I think we're prepared to do that as well, if we wanted to.
Is there anything else the commission would be interested in amending?
I think you've covered it pretty well.
Yeah. Well, how does the commission feel about having a stepped fine schedule?
I like personally from just the consistency of how it compares to the adjacent communities, obviously the depth of the same issue, I think it makes it probably more palatable in town meeting to not be among the communities with the highest without the step. So I'd like to make a motion that we make that change. And we consider a step, we take action on implementing a step system.
What amounts do you, and what steps do you foresee? Can you amend that into your motion?
I'd have to look at that, but I think I was seeing.
100 first offense, 200 second, and
It was
300
even lower. I
first.
think 25 was the first offense and then it stepped up.
I would say I would,
I think the whole point of the fine was it provided
yeah,
Make the
teeth to
motion.
something.
yeah.
$25, I don't think provided teeth.
All right, well, I second the motion to have a stepped fine. I don't agree with $25.
There's only one town that starts at $25, and that's Raleigh.
I don't think that would be a deterrent. I think that would be kind of,
And that would be perfectly acceptable to the beginning of that.
I would start with 100.
all right, well, so,
A motion to amend the bylaw for stepped fine, starting at $100 for the first offense, $200 for the second offense, then $300 per violation per day, continuing thereafter.
Yes. So to clarify, $100 day one. What happens on day two?
$200,
Okay, and day three?
$300.
So we're introducing complexity to the fee schedule for $300.
Fine schedule.
That's fine schedule, yes.
It is
I know,
different,
it's
it is very
important,
different.
important. I apologize. If it's optics and if people are gonna change their minds about the bylaw because of that, I'm all for it. I don't know that anybody's gonna change their mind. We're already vacating fees and suspending fees completely or partially, depending on the needs of, you know.
this would make a week's worth of fines $300 less.
Yeah, so I'm totally happy to do it. I don't feel, I think it's a pure optics thing that adds extra lines to the bylaw, unnecessarily. Just,
Well, I think it's beyond optics. I think it's making the bylaw more in line with other towns' bylaws, making it look like the other towns.
Will you entertain a question during this conversation? It's Zoom. Barry has his hand up.
Oh, sure.
Sure.
Barry, you can go ahead.
I was just gonna suggest, I mean, it doesn't mean that first offense means the first day. You could, if somebody at 2 Smith Lane commits what you believe is a violation and you assess a fine of $100 a day, that gets resolved. A year and a half later, they commit a second offense or something that you think that's their second offense. So it can go $100 a day if you cross paths with the commission the first time, and then it's $200 a day for the next time you are an offender. So it depends on how you write what the first offense is and what the second offense is, because if you have language in there that says every day is a separate offense, then I think the gentleman is right that it's optics. I mean, it doesn't change my mind either way, but I think you have to give some thought to what the first offense is. Is it the first day of an offense, or is it the first time you committed an offense of the local bylaw? You get my point?
I do. Trying to think about how the Wetlands Protection Act has it, and I think they view it as individual offenses. So offense one is I clear cut all of the trees along the river, right? So DEP today could start issuing fines at $25,000 per day on that. But then up to, because they didn't have KP Law review it and tell them they couldn't. But then that same person, 2 weeks go by and now they bulldoze fill into the wetland. I think that is a separate violation that kicks off that separate, fee per or fine per day. That's my read of how the Wetlands Protection Act is segmented, and I would suggest that the commission, view it at that. You might have a situation where day one, that tree example, we send a letter, we issue an enforcement order, we're not getting resolution, they're not reaching out, so now you start with that $100 fine per day. And then maybe that's enough, maybe now they come in, they propose a planting plan, but then next year, they do something else. Is
That's
that
a separate enforcement order. I would think that would be a separate.
Keep in mind, by the way, there is a state law for local fines that you have to issue the citation in order for it to be enforceable in district court within 15 days. You can't wait 6 months, where you've been fiddling around, my words, to try to get somebody in line. And then if they misbehave, assess a fine. So take a look at that with KP, because I just dealt with that where a fine was dismissed because the citation had not been issued timely.
Right, that's why we have the provision to be able to suspend the fine, so we can issue the fine and then suspend until hopefully we resolve and vacate. We work through this.
Can I have a question?
Yeah.
Where is the word offense defined? It isn't in this bylaw, and perhaps it's in the Wetlands Protection Act, and I'll explain why I'm asking. Based on a couple of questions tonight, it seems to me as though there may be an impression that if there has been an offense, say you clear cut an area that shouldn't have been clear cut, there may be a perception that until you've mitigated that or you've cured that it continues to be, you continue to accrue offenses on a daily basis.
It's actually how
And-
that works.
Excuse me?
That is in the act.
Oh, okay, so,
If you fill a wetland every single day is a separate offense, and it continues to be.
until you've unfilled.
Until you unfill it, yeah. That's
So,
state law.
Okay, so, and if you clear cut trees,
and so the
is
commission.
it, I'm assuming it's not, you don't continue to accrue
Until all
offenses
your trees
until
are
all your
planted.
trees have grown back until,
Every year old.
so I guess I'm just trying to make sure that people aren't over-interpreting what is an offense, and maybe, maybe I'm under-interpreting.
I
So-
think people are over-interpreting, if I could, and I think the bylaw is pretty clear that unlike the Wetlands Protection Act, which doesn't have any provisions of good faith, or you're working with DEP, that if you're working with the commission towards restoration, they'll suspend fines. And if you get to that point of mitigation, you worked with them the whole way that they'll vacate the fines.
Okay.
So it's not until those trees are mature and established that you're free
Okay,
of fine
I guess next, I'm just suggesting that next time there are questions along those lines, that be explained.
Okay.
Good.
So Molly, I think you have a motion.
Okay, so the motion is to have stepped fine schedule, a stepped fine schedule of $100 the first day, $200 the second day, $300 the third day, and every day thereafter.
I second that motion.
Yeah, we're discussing altering that to be offense day. I don't know, like, I get concerned about that then because your first offense could be, it might be small, but it could also be.
could I add to the discussion? I like the simplicity of one fine. If the commission feels that $300 is too high, it doesn't like the optics that puts the commission in. And it's just looking at some Essex County communities, it's not the whole state, it's not even all Essex County bylaws. If the commission feels that the optics of $300 is too high of a fine, I would suggest reducing the fine to $200. I think trying to do steps, and then I think Barry raised great points, you know, how are you considering that? How are you interpreting that? I think that opens up a lot of additional work for really no gained result on that. So I think if the consideration is optics and maybe people will be more inclined to approve a bylaw that they feel has less stringent fines. Then, you know, after this conversation, I would suggest, in my opinion, the motion be altered to reduce it to just one lower fine, but have it set, it's X dollars per violation per day, and instead of the stepping.
Right.
Do you think 200 is the right number? I mean, would 100 be effective enough? I mean, it's all this question. I don't want somebody with a lot of money to just be like, I can just ignore the fine forever. And obviously 300 and 100, they're arbitrary numbers.
They're arbitrary.
You know, and I know the minimum parking or speeding ticket is $100, right? If you're speeding 1 mile over and they actually give you a ticket, it's $100, right? There's a lot of $100 fines around that is the minimum. That convinced me we shouldn't be doing it at 100.
I got nothing. I think at least 100. I think anything under $100 isn't gonna really have teeth, right? Because, and I think we've had this conversation though, and that's how we came up with $300. Because what is the filing fee to submit a permit? It's $100 for most of our violations.
Too expensive to ignore.
Right, and that was the idea, make it too expensive to ignore. So if you set a fee at $100 per violation per day, you only collect $100 fine, then you've actually essentially allowed an activity to occur at less cost than what it would be if they were to permit it
And it
under.
takes your time every day to issue the fine, which we want to respect.
So, yeah, I mean, so I guess that's my only take on having.
An argument for 200.
Yeah.
Over 200 over 100, and I mean, I think 200 is still low, but I think I hear you, right? If you're trying to not be in the top tier of the highest fines in our immediate adjacent neighbors, then, you know, $200 kind of meets in the middle.
I think the whole idea of this slide was we wanted to show how we compare with our adjacent communities, right? And that we weren't an outlier one way or the other, and that is, we really are the outlier.
By a little bit in.
No, not 200, at the 300 period.
Well, and so the argument was that $2,100 for a week is too much, so this would be $1,400 for a week.
Which would be less than almost all the other communities.
And I think honestly, having it $2,100, if you have gotten to the point your violations are so severe that the Conservation Commission is issuing fines and you're, you know, on day one, you get the fine and you're not in talking to me to figure out how we can fix it and telling me that you're gonna come to the next Conservation Commission meeting. I think at that point, looking at $2,100 per week is not unrealistic, or $1,400 per week, whatever fine number you pick. It sounds so severe because it is, because at that point you're committing egregious violations. You're actually hurting wetlands and you're hurting the community.
So perhaps $200 per day would be acceptable. The thing is, we rarely ever actually charge somebody, well, there's nobody here to hear that. So.
Right.
We're online, so.
Yeah, there's still people on.
Still being recorded.
Yeah, I think, no, I mean, you're right. This is all very speculative because we've never had the opportunity to charge fines or to see how it would work, if it would actually be effective as a deterrent or as a tool to bring us to
And
respond.
unfortunately, I think, you know, the odds are we get one chance. Whatever I doubt we're gonna go back to town meeting to get an amendment to the bylaw to adjust the fee schedule by $100 one way or the other.
I can think of one situation right now that's been years and years and years that would probably be resolved right now if we had these problems.
Oh, you're absolutely right, there is. And I think everyone would be so much better off. So with that. So I'll amend the motion to move that we retain the simplified fine schedule, but reduce the fine to $200 per day.
I second that.
Any further discussion? All those in favor?
Aye.
I can get that to you tonight or tomorrow morning, first thing, I guess.
Friday's fine. It's an
I'll
easy,
get it to you before. Friday.
well, yeah, actually, no, it's good, I mean, for Thursday night, the select board can come. But in terms of the booklet, it's an easy change to make. I just want to make sure I had it right, so.
Yeah, appreciate it. Yeah, we all like to make sure we can burn it.
All right, is there anyone, one step on toes, is there anyone else online that has any comments or feedback on the wetlands protection bylaw? If not, we're gonna go ahead and close down this Zoom session. It is recorded, so it will be posted on the town's YouTube shortly.
Thank you all for participating. I think, we're only gonna have a good bylaw if we have participation.
All right, thank you.
Thank you.